statutes don't override the Constitution. This judge doesn't understand that, obviously. We swiftly reviewed thousands of awards, and we decided, Supreme Court, to retain over 500 USAID awards, worth $57 billion. Ugh! That individualized review, now largely complete, resulted in $57 billion of your taxpayer dollars still going out to the so-called AIDS doctors. And they're still mad. We want more. President Trump, now at the Supreme Court, he submitted his reply in support of an application to get rid of that order from the lower level judge called Amir Ali to pay $2 billion out to NGOs who shouldn't be getting it because Trump canceled it. So this is what we're going to go through at the Supreme Court very soon once the Supreme Court decides what happens next. But we also have another case that's knocking on the door there, and that case, of course, is the case of the special counsel suing the Trump administration to get reinstated back in his position. This is Hampton Dellinger. He was fired by Trump immediately and sued to get put back in office. Now, this case is also at the Supreme Court, but this is not a Supreme Court opinion. This is the lower level judge's opinion that needed to come out before the Supreme Court would act on this case. Remember, Trump appealed this directly to them, and they said, well, we're going to hold everything in abeyance on hold until this judge issues this ruling. This judge has now issued this ruling, and it is adverse to Trump. So that means we're going to go back to the Supreme Court on both of these cases, one on the AIDS doctors case and the $2 billion, and one here on Hampton Dellinger. Now, here is what the judge said with Hampton. Says, look, he can go back into power, saying, as of the close of business day on February 7th, this is Judge Amy Berman Jackson writing, a Democratic appointed judge. She said Hampton Dellinger, before Trump came in, was appointed to a 5-year term. He served as the head of a small independent agency. It's not independent at all. It's the Office of the Special Counsel, which lives under the executive branch. And they're tasked with shielding federal employees from prohibited personnel practices, included whistleblowing. Okay, so it says he was employed here, but then at 7:22 that evening, he received an email message above right here. This message to Hampton said, on behalf of President Trump, I'm writing to inform you that your position as special counsel as of now is terminated effective immediately. Thank you for your service. Get the hell out. The judge says he was sitting there at 7:22, and then Sergio sent him an email with no additional explanation or reasoning. So the judge is like, well, I don't approve of this firing. So then on Monday, Hampton sued. He sued Scott, Treasury Secretary, and a bunch of people. Then he moved for a TRO, temporary restraining order. Then Trump moved for summary judgment, saying, Your Honor, you don't have the power to shove this guy back in office. She says, well, look, there is no dispute that the statute, right, the congressional statute, and by the way, just to be clear, statutes don't override the Constitution. This judge doesn't understand that, obviously, but they do this all the time. They reference congressional statutes and they say, well, Congress signed it and the president signed it into law. Well, they play patty cake all the time to violate our constitutional rights, and they get away with it all the time. Just because Trump is saying, I don't care what that unconstitutional law says, doesn't make it valid. Or the fact that nobody else has exercised or flexed their executive branch power doesn't make it invalid or constitutional. So they said, you can't get rid of us because the law Congress wrote says you can only remove them for inefficiency, neglect of duty, or malfeasance in office, which is in direct violation of Article 2 powers. If they wanted to write a constitutional amendment and put that in there, that's fine. I can't argue with that. But they didn't. They wrote a garbage statute, which is illegal. This is the basis for count 1, which alleges the termination was unlawful because Congress said you can only fire him if. So Trump takes the position that this is illegal. It's unconstitutional. It should be struck down, and it will be. They insist that the president of the United States must have control over all agencies, even small federal agencies, notwithstanding its narrow focus or negligible impact, right? The judge says, well, it's a small agency, so the Constitution doesn't apply. She says, well, it's an agency that doesn't have a lot of impact on certain people, so the Constitution doesn't apply. Now, Congress did not disagree with this or any of those things. It enshrined presidential control in the statute by saying you can only remove them for specific reasons. They say, no, I can fire them for any reason at all. The judge says, the question for me is whether the president's Article 2 powers say he can remove him, whether it's an unconstitutional intrusion or not to prohibit him from doing that. It's an extremely narrow question with little or no precedential value given the sui generis nature of the Office of Special Counsel, created out of nothing, right? Kind of like of an original form, saying we've never really dealt with this issue before. Yes, we have. We have 2 Supreme Court cases that have addressed this specifically. The court finds that the statute is not unconstitutional, of course, and it finds that the elimination of the restrictions on Hampton's removal, so in other words, if you said that the president could terminate this person at will, it would be fatal to the defining and essential feature, which is the independence of the agency. Signed into law by the president, it's a statute. And if the feature is its independence, then judge, where does this live? Where does this reside? Is it under the executive branch? Is it under the legislative branch? Where is it? They just make it up. This court concludes that they must stand because Congress passed it and signed into law. So they just create these new agencies without any constitutional amendment that live in their own branches. It's sick. It's the theft of our country away from us. And it's happening by judges and politicians who are doing this. This is legal grift to the same tune of USAID billions, okay? This little interpretation, if you extrapolate this out, is $1 billion, if not $1 trillion damage to this country by saying we can have these so-called independent agencies that just exist on their own. It's just like when we look up these NGOs or these taxpayers or Data Republican, right? USAID or any of these funds. Where are they? They're just kind of existing in the ether. The legal precedent that allows that to happen is this patty cake game between the executive branch and the legislative branch where they create these independent garbage agencies and shove them into the ether. A review of both of the statutory provisions setting out the powers and functions and the history of the legislation reveals that its independence is inextricably intertwined with his duties. She's acknowledging my whole point here. The special counsel's job is to look in and expose unethical practices. And so she says his job is very important. She thinks it's important. So there's a constitutional exception if a judge thinks it's important. Moreover, striking down the removal provision is not necessary. This court has ruled in these other cases, right? These are the other two I was referencing earlier, Seila Law and Collins. And Seila Law went after the CFBP agency and said, no, you can fire the head of the CFBP. Collins went after the FHFA and said, oh yeah, you can fire the head of them too. So these two cases are precedential, in my opinion, for this same extension of the law. In other words, that the special counsel can be fired at will by the president. But she says those cases do not require a finding that the removal protections are unconstitutional because they're different agencies. Okay, so now she's going to distinguish her case from these cases because they're not the special counsel's office, as though she's going to point to some constitutional provision that allows her to do this. This case also does not present an affront to Article 2 authority. What troubled the court in Seila and Collins were restrictions on the ability to remove because they wield significant executive authority, but says the special counsel doesn't do the same thing. So his role is less important than theirs, even though this person can prosecute people and investigate and issue subpoenas and all the things. No, they're just like a liaison. It's just like a counselor. They don't even have any power at all. It's not significant executive authority. It's hardly even executive at all. Great. So she's admitting it. It's hardly even executive authority at all, but it is executive authority, isn't it? Thank you, Judge, for just agreeing. So if it is executive authority, then it lives under the executive branch because there is no special counsel branch of the government. Finally, the underlying assumption is that the president needs to be able to control his office, but this is that. A special counsel shines light on this. And so it's actually going to enhance the office of the presidency. And so in sum, says this very corrupt judge, Amy Berman Jackson, District of Columbia, who should be impeached and removed from office, it would be antithetical to the very existence of this particular government agency and position to vindicate this as it was described in Humphrey's Executor, which is a constitutional license to bully officials in the executive branch into doing his own will. That's his power. It's not bullying if it's your executive authority to do it. Weird judge. For those reasons, it is granted that the Hampton-Dellinger motion succeed and Trump's motion lose. Okay, so Hampton-Dellinger can stay in power for the foreseeable future. And this is a memo opinion on the preliminary injunction in the TRO. So now it's up to the Supreme Court to decide what to do about that. Now, another judge that has been responsible for a lot of this is Amir Ali. Remember, he's a very young DC judge at the district court level, and he was born in Canada, along with Judge Chutkin, Judge Merchan, and many others in the District of Columbia. What we can see here is at the Supreme Court of the United States, President Trump submitted his reply. This came in from his acting Solicitor General called Sarah M. Harris, and this is another TRO. This is another essentially injunction by a judge forcing the Trump administration to do things that are within the Trump administration's power. Article 2 says Trump can do these things. It's written down in the Constitution. Trump does them. The courts say you must stop and you must reverse. So in this case, these are the so-called AIDS doctors and the Global Health Council, right? Just like the Institution for Democracy. They mean nothing. They're an AIDS vaccine advocacy coalition. Is there an AIDS vaccine? Are they advocating for one in a coalition? Wow, what a bunch of heroes. So you can see that they are suing because they're such good public civil servants that they want their money to be turned back on because they don't really care what the American people think because we voted and made an election occur and wanted these changes to unfold. And now they say, well, you guys were wrong. You have to pay us our money anyways. So they sued. And the way this case got to the Supreme Court was wild because the judge at the lower court level, Judge Amir Ali, born in Ontario, said, you got to pay this $2 billion by the stroke of midnight or else you're all turning into pumpkins. And Judge Roberts woke up middle of the night, late at night, came back out and and signed a stay that said, actually, you don't have to pay that money out. It's $2 billion. So of course, now we're there at the Supreme Court with these arguments. Trump is responding saying, keep that money turned off. All right, here's why. Said when a district judge like Amir orders the United States government to pay $2 billion in foreign aid funding pending payment requests within 36 hours or else face judicial consequences, Your Honor, that is an immediately appealable injunction. Okay, he can call it a TRO, he can call it a stay, they can call it whatever the hell they want. If they're forcing us to pay $2 billion in 36 hours or we're in trouble, there's nothing else we can call that. So it's an injunction. We should be able to appeal it. That's why we're here. And the order in these two cases manifestly warrants a vacatur of these orders. So they both should be nuked immediately. And these are two companion cases that got set together, the AIDS doctors and the Global Health Council, whatever. Said ordering the United States to pay all pending requests on a timeline of the district court's choosing without regard to even whether the requests are legitimate, whether they're even due, that intrudes on the president's broad foreign affairs powers and upends the system that the executive branch was established to occur, to disperse the aid. So we have the power to do this, and now he's forcing us to send the memo, put it on a timeline, pay it even if it's not due, pay it even if it's fraudulent, pay it if it's even canceled. It's theft of billions of dollars from the court. They don't have Article 2 power over those funds. Nobody elected this judge or these AIDS doctors. Compounding the problem, the district court also lacks any jurisdiction to resolve this anyways. Congress has given an entirely different court called the Court of Federal Claims exclusive jurisdiction over this type of dispute when it comes to government contracts and grants. There's a whole separate system of courts. You've heard of like DUI courts or like domestic violence courts or drug courts or veterans courts, right? Court of Federal Claims. Oh, you think you're supposed to get paid from the government? Here's a whole court system set up just for you since there's so many of them. The February 26 administrative stay relieved the government of the 36-hour deadline. Thank you, Judge Roberts, for doing that. Now, vacatur is warranted to prevent reinstatement of this. So like, we're not paying this money out because you said we don't have to, but we want you to vacate the order in the first place. Get rid of this short-fused deadline that would unlawfully commandeer federal payment processes anew. Saying these so-called doctors, they downplay the 36-hour pay order. They say this is a continuation. This is not an injunction. No, it's an order that just is telling you to just comply with the original temporary order. Because if it becomes an injunction, then it's appealable. The TRO is only supposed to maintain the status quo. Obviously, that's not what's happening. The respondents call the government's inability to comply a problem of the government's own making. But no, the original TRO, Supreme Court, while objectionable in many other respects, it did not require any specific payments by any specific time. That's all new. It said only that the agencies could not enforce the administration's new blanket pause on the funds. And so we didn't do that. We followed that. That TRO at least permitted federal agencies to enforce the terms of the contracts or grants on an individualized basis, including by deciding to terminate them going forward. Okay. So what we have identified here is the independent source, because Trump issued the executive order, then Rubio issued the memo and said, pause all the money. Then they sued. The original TRO said you can't rely on the order or the memo to effectuate the pause. They said, okay, fine. Who cares? We don't even need those. We can just look at the contracts and cancel them on a case-by-case basis. So they did that. Now, far from refusing to comply, we did. The agencies issued directives to contracting officers and said, comply. Then they expended significant resources. We swiftly reviewed thousands of awards, and we decided, Supreme Court, to retain over 500 USAID awards worth $57 billion, as well as about 2,700 state awards. You have to understand how much money that is. Like, just think of the market cap of some of the biggest companies in the world. What are they? In the billions. So 57 billion. How much revenue does Apple produce in a year? Think about that as a global company. I don't know. Is it about that? 50 billion? I don't know. Think about that. Going out for God knows what. Meanwhile, the agencies developed and began implementing, like, we just think of numbers. It's just big numbers. We can't fathom them. It's so much. Meanwhile, the agencies developed and began implementing procedures for processing payments, already completed work to better guard against fraudulent or improper payments. The 36-hour pay or else order arose from them. On the evening on February 24th, they filed a new emergency. We're going to die if we don't get our money. Grandmothers are going to fall out of airplanes with AIDS. They insisted that operations of several respondents and their members would not survive the week unless the government paid the amounts. We're all going to die. We're starving, man. We can't order any pizza right now. Paid the amounts owed under the grants. They demanded immediate payment on all pending requests for all aid recipients. Without asking for any additional briefing or evidence, Judge Amir Ali from Ontario held an emergency hearing, granted that sweeping relief from the bench, set a 36-hour clock for the government to pay all invoices and issue a letter of credit now. Unlike the original order, this new order does not permit the government to review the payment requests individually individually, or even to limit itself to requests that are actually due. You pay everything and you pay it now. I don't even care if it's going to, AIDS Doctors or Us or whatever, on 4th Street or whatever. I don't care. Pay it. Nor would such a review even be possible on the district court's invented timeline. But nonetheless, the State Department expedited millions of dollars in identified payments to 2 respondents, and we prioritized the processing of additional payments to other respondents. But the government cannot just press a button and hand out $2 billion like the judge wants. Instead, the government must undertake a multi-step process that complies with federal statutes, by the way, before payments are authorized. The government thus sought immediate relief from you to avoid non-compliance with an impossible order. This is the impeachment trap, okay? This is an impeachment trap, okay? Somebody's thought this through. And they're trying to push Trump in order to create a breach. They want Trump to create a breach. When there is a breach, there will be calls for impeachment. The district court now stands on the brink of placing in the constitutional crisis. He's in direct violation of an order. These judges are creating impossible orders to comply with. On February 27th, they then expanded their scope to Judge Amir Ali, asking the court to revoke all terminations. So your grants are canceled. We looked at the contracts and they're canceled. They said you have to revoke that. Bring the contracts back. They said, what? The original order from this very judge said we could cancel these. He said you can. If the contract says you can, you can. But then the judge says, no, you can't. Restore everything as it existed. This court obviously should prevent what began as a putative APA challenge to policy memos from further escalating into decisions about foreign aid. By the way, court, the Constitution vests the executive branch, not the judiciary, with the power to control foreign policy. That's the president, not Congress. Now, Trump's DOJ writes via their Solicitor General, they also say to you, Supreme Court, that you have no jurisdiction here. They say all that you can do is just have them comply with the initial TRO. But, Your Honors, Supreme Court, what matters for appealability is not the order's form, but whether it has the practical effect of granting an injunction, okay? You can label it whatever you want, okay? But we know what is under there. We know what you're doing under there. We can see it. Can't miss it. It's an injunction, and a big one. Now, lower courts cannot foreclose appeals by labeling injunctions as minute orders. You can't just call it something else. We know what it is. Here, the district court issued a minute order on its docket. They called it a minute order only because it had orally ordered sweeping relief from the bench, right? And like, okay, well, that was an injunction from the bench. Don't call it a minute entry. And in February, there was a new order that imposes new mandatory obligations that the original TRO did not require at all. And so that creates an immediately appealable order. So we can be here, judges. The original TRO, even though it was erroneous, it simply stopped the agencies from enforcing the memo and pausing any future funds. But the district court refused to stop them from looking at the contracts. Then the court clarified the TRO still permitted them to end these awards if they were complying with statutes, regulations, and other legal authorities, right? This judge goofed too. He kept tightening his orders. And the court expressly disclaimed any intention of supervising them. He says, we can't litigate every breach of contract case here. The TRO was intended to restore the status quo. Now then the order also, it was styled as an order to enforce. Okay, they said, well, no, it's not a new injunction. It's not a new order. It's nothing you can appeal. We're just telling you how to enforce the original TRO. But then it required payments within 36 hours. All invoices, all contracts, letter of credit, drawdown requests, and more. $2 billion flooding out the doors. The order does not permit the government to conduct an individualized review at all. It takes total control away from the executive branch, gives it to this judge. The order does not allow the government to confirm that the request is even legitimate. It's condoning fraud. And the order does not distinguish between requests that were actually due or unpaid. Everybody gets paid for everything because it's floodgates time. Nor did the order address the logistics or the practicalities. Now, those commands are not consistent with the original order. The original order was to return the status quo. That's not what's happening now. They are a further break from what the government had previously done. Well before the funding pause, even our internal policy manual at the State Department said you got to check to make sure it's legitimate. The status quo says we got to check to make sure it's legitimate. That's what we're doing. And it also says you get 30 days to make reimbursement requests. And they never explain why some $2 billion in payments must all have been paid by 11/59. Why is that? Why do you want all your money? It's my money. I need it now. Presumably in large part because the record doesn't contain their contracts or even their payment requests. Okay. It's like AIDS doctors. Well, what does your contract say? Are you supposed to get paid? What does it say? Did you submit your contract? No. Do you submit anything that shows you're entitled to these payments? No. So you're just here complaining that everybody's going to die and you should be paid. Yeah. And the judge bought it. Now, the February order qualifies as an appealable order. The order has the practical effect of granting an injunction, and that is appealable. It compels the government to affirmatively act to disperse $2 billion in a short time frame. That requirement is about as final as it gets. Once the money leaves the federal treasury, the government is not getting those money back. And an order may be more appropriately characterized as a preliminary injunction when it has irreparable consequences like stealing $2 billion. $2 billion! Courts of appeals have regularly allowed appeals like this. That's why we're knocking on your door. Now, their contrary theory is untenable. Under their view, the district court could apparently order the United States to pay any sum on any deadline on pain of contempt so long as the payment demand relates to foreign aid. And the government could never appeal, no matter how unlawful the order is, and all the money can be siphoned out before anybody can do anything about it. Now, the AIDS doctors and the thieves, they respond. They say that vacating the February 25th order would be pointless since the district court's original TRO would be in place, saying, well, if you just get rid of the order to pay the $2 billion, then the pause is still in effect. They echo the lower court's insistence. They say the challenged order in no way modified the TRO terms. But as explained, the order plainly requires the government to do far more than the original TRO. They're different. One is making us do something, the other is preserving the status quo, also unlawfully. Before this litigation, the government could have conducted an orderly, individualized review of the payments and fulfilled the payments requests without delay. And these people could have sued in the appropriate venue in the Court of Federal Claims. The initial TRO, although it was unlawful for this judge to even do that, did not appear to disrupt any normal payment resolution processes. So we could still pay people, but this does. It says you can't even check for fraud. All payment requests must go out. They created some specific and arbitrary deadline regardless of any disputes. And they're wrong to fault us for this problem of not being able to comply within 36 hours. Neither the TRO nor the court's order made a requirement ever to make all these outstanding payments at once, let alone by a specific date. And the reason the judge put this deadline so close is, again, it's an impeachment trap. They're trying to cause Trump to create a conflict. The government, understandably, had not been informed that you would make us pay $2 billion at midnight. Vacating their payment order would not open the floodgates to emergency relief. This court and lower courts have heard these things before. This court would not be breaking any new ground by hearing this case. If anything, their arguments risk igniting more emergency repeals. Like if they win and this is the default rule, we're going to be back here many times. If a defendant could appeal compulsory orders only by appealing an initial TRO, that would spark more emergency litigation, not less. So hear this case, settle this so we don't have to do this over and over again. And we're going to win, by the way. Trump's DOJ to the Supreme Court says, this court, the Supreme Court, you need to hear this case because the lower level court is trying to micromanage Trump with serious and irrevocable consequences. They have ordered the government to pay billions of dollars in foreign affairs. That's the president's job. And the court did so without even seriously evaluating its jurisdiction to do that. It doesn't extend to this. This court can't even order this to happen. We've already explained. It's a contract problem, and contract problems with the government are resolved in the Court of Federal Claims. So this judge should have dismissed this immediately. The government retains its sovereign immunity from their contract claims everywhere else. You can't sue us for that. We created this special forum for you for these claims. But instead of grappling with those limitations on its jurisdiction, Judge Amir from Ontario postponed their consideration. He says, well, you know, I'm going to talk about standing and whether you even should be in this court at the later stage. But for now, because it's an emergency, we're going to make them pay you your money. The extraordinary resulting order cries out for the Supreme Court to intervene. Now, they can barely defend the legal merits of the lower court's order. They don't argue that the court considered the government's jurisdictional arguments before entering that order, as it was required to do. And their defense of this court's jurisdiction is one cursory paragraph. But this court has clarified that Bowen doesn't cover cases like this. This court explained that suits involving prospective, declaratory, and injunctive relief in ongoing complex relationships are properly brought here. And this order, which compels us to pay certain things, meets the standard. The district court is not awarded prospective non-monetary relief or purported to manage an ongoing relationship. It's ordering and requiring the government to promptly pay now. And they don't even engage with other reasons why ordering us to pay out billions brings this within their jurisdiction. They don't dispute, for example, that other areas of the law govern these cases. They dismiss our jurisdictional argument. They call that tentative, like we shouldn't be here in the front of the Supreme Court, but they're not addressing this. This court should hear this case. As we've explained, it violates the core principles of equitable remedies. The remedy should be tailored to the injury. The court's failure to abide by Article 3 doesn't give it license to do whatever it wants. Now, the district court has threatened to even make it worse. They're going to allow wide-ranging discovery and subjective motivations of senior officials. Like, I wonder if they did that in good faith or if they did that lawfully or reasonably or whatever. Not their decision. They're going to continue to allow this to metastasize into judicial supervision of the executive branch. And we cannot allow that to happen. It's in clear contravention of the Constitution and Article 2. And so they argue that the government brought this order upon itself. That's wrong. This dispute over the lawfulness doesn't require the court to even wade into the broader facts. The agencies followed the district court's order and the TRO. We paused. We stopped pausing the awards based on the executive order. In fact, we went through an individualized basis and a multi-step process, and we terminated them on our own. That individualized review, now largely complete, resulted in $57 billion of your taxpayer dollars still going out to the so-called AIDS doctors. And they're still mad. We want more. The agency's decision to continue tens of billions of dollars belies any notion that they are proceeding under the pause, because they're still giving them out. Yet despite those efforts, respondents and the district court continue to express concern that our terminations are pretextual. They even wanted to pose Rubio about his termination decisions. How dare Rubio do this? We want to talk to him. They believe that the agencies were not complying with the original TRO because they didn't get paid. But the original TRO did not instruct us to pay them. The judge said a bunch of things in the clarifying orders, but he never said we had to make payments to them. And the court did not forbid us from making sure that payments were legit. So regardless, the district court's frustrations with the government regarding the initial TRO does not give them subject matter jurisdiction to hear this or then to force us to pay. A court may not act when it doesn't have jurisdiction under any circumstances. Like, this judge might be mad as hell that somebody in his family or his wife or, his lover or whatever, I don't know what's going on, is not getting paid, or the AIDS doctors that he really cares about or whatever. That doesn't give you jurisdiction. They deny that this injures the executive branch. They say, well, you guys got plenty of money. You just print it anyways. It's just peasant Americans who have their livelihoods stolen from them in the form of taxation and inflation. But the government merely presses the vision of the Constitution. We have an obligation. It should be self-evident that the district judge is trying to preclude the government, the Trump administration, from conducting due diligence before making billions of dollars of payments out. Now, they say it's just speculative harm. You can't speculate that these payments are illegitimate. Saying the government cannot provide evidence that any request is illegitimate, they argue that the government's harms are remediable. They're not irreparable. But they don't dispute that they don't have the funds. Like, they can't pay these funds back if these funds are illegitimate. So then they repeat over and over. They say the government refused to comply with the TRO, and that's why you need this, but they just keep moving the goalposts. So on the other side, they also show how vacating Amir's order would cause them irreparable harm. They assert that they would face irreversible harm if the funding freeze continues. But the funding freeze is not continuing, okay? The funding freeze is over. The State Department has largely completed their individualized review and decided to retain thousands of awards, saying that your original challenge to the freeze is now moot, okay? So you guys wanted to stop the freeze. We did. You sued to unfreeze everything. It's great. There is no more freeze. Your contracts are now canceled, though. As explained, the order at issue here is far removed, and the judge says, well, pay them anyways. Redo those contracts. Well, your original order said we could use the contracts to get out of the deals. But I didn't mean that. Now pay them. Now their declarations describe their immediate need for payment. But vacating the February 25th order will not prevent them from having their payments processed. Agency leadership has already represented that millions of dollars in payments were being issued to two of the respondents here. We're already going to pay you AIDS doctors and you global health whatever for your work, so stop your whining. Moreover, at Rubio's direction, invoices identified to other lost people here suing are being processed and expedited. We're just going to go through the regular vetting procedures. We're going to pay them. And if the government's payment of past due invoices is not to their satisfaction, then they can sue in the other courts. Now, what they cannot do is leverage their individual equities into a wholesale pay or else order affecting untold numbers of requests, disrupting the ordinary process, and thwarting Trump and the executive's control of foreign aid disbursements. And so, for the foregoing reasons, we ask that you vacate Judge Amir Ali from Ontario's opinion, signed by Sarah M. Harris, Acting Solicitor General to the Supreme Court of the United States. A good filing. We hope that the Supreme Court acts with haste here, because what we're seeing from these lower level judges is corruption and disgusting. Now, the question is, what can we do about it? This dude, Justin Murphy, I encourage you to give him a follow. He's over there at J Murphy, without the U, on X. Published this. Says, the New York Times this morning criticized Elon's call to impeach federal judges, accusing him of violating constitutional norms. Well, I looked into the data. It's insane. We stopped impeaching federal judges despite having more of them than ever. See this? We used to impeach a lot more of them. In the 1800s, we got 2, 1830s, we got 1, 1860s, 1, lots and lots and lots, but that number has stayed the same, right? It seems like it should kind of be matching that upward trajectory of federal judges. The impeachment rate seems implausibly low. Either federal judges have become saints or something is suppressing the impeachment. See this? Impeachment rate per 1,000 judge years. Look at this calculation. Smart dude. Says, what is the probability we'd observe 0 impeachments from 11 to 24? Using the Poisson distribution, I think it's somewhere around 3 to 7 7%, depending on how you do it, so it's very fishy. What's even crazier is that there is a clear political story behind all this. The 1980 Judicial Conduct and Disability Act, signed by Jimmy Carter, gave judges the power to police themselves through an obfuscated, multi-layered system where chief judges dismissed almost all the complaints against any judicial counsels, and they choose confidential sanctions in most cases, right? When's the last time you heard of a federal judge getting in trouble with anything, anywhere, for anything at any time? Then in 2008, the federal judges reformed themselves, which seems to have made things even worse. He's going to look into it more. Seems the New York Times is wrong. Musk is right. We need to do more to impeach federal judges, and we're fully on board with that idea. And of course, we're going to keep our eye on what's happening out of the Supreme Court with these AIDS doctors and Amy Berman Jackson and her illegal special counsel that she's shoving back into the Trump administration for her own nefarious ends. Thanks for subscribing and joining as we do.